Morning, everyone, and welcome to Preparing for Your Strata AGM. Really great to see so many people attending on a Saturday morning. So I wanted to tell you just a little bit about me. I am a former VISOA board member. I was on the board for about 12 years, 8 of them as president. I am not a lawyer. I'm a Strata owner, just like you. Strata owner since 1992, and I always remember the date because my Strata fees were $92.92. And in my time as a VISOA board member and on my own Strata council, I've planned and chaired many an AGM for my own Strata, for other Stratas, and of course for VISOA. This is what we're going to cover today. We're going to cover these few things. When must the meeting be held? We'll cover preparing the notice package, what must be in the notice package, what's on the agenda, how to get that notice package ready, how to write resolutions, and how much notice is required. So what does the Strata Property Act say? So this tells us not a whole lot. This tells us what we need to know about annual general meetings. So it says we have to hold annual general meetings except as provided under section 41, which we'll talk about in a little bit. We have to hold our annual general meeting no later than 2 months after our fiscal year end. However, there is some small updates because of the COVID-19 situation. So strata corporations have an additional 2 months to hold a general meeting in any provincial or local state of emergency. And also we can hold electronic AGMs and SGMs during a state of emergency, even if you have no enabling bylaw. So that's good to know. And you can find more at the BC Strata Housing website. Your notice package has to contain some very specific things, but note in Strata Property Act section 46, part 1, the council determines the agenda of an annual or special general meeting. So that's important to know. Keep that in the back of your mind. Subsection 2 says that persons holding at least 20% of the Strata Corporation's votes made by written demand propose a resolution or raise a matter. And so what that means is the owners can petition the council to either add a matter to the AGM or to call an SGM for a specific topic. 20% of the owners, 20% of the Strata Corporation's votes would need to do a petition for that. But otherwise, the Strata Corporation, the Strata Council determines the agenda. Now, what your notice package must contain also, you need to ensure that if you have received a petition of owners, you need to include that in your AGM package. The petition matter is still on the agenda. It doesn't say it has to be first. It just says it needs to be on the agenda of that meeting. That's a frequent question that we get at VISOA is, does this matter have to be first? No, it just needs to be on the agenda. So other things that need to be in your notice package, if there's anything that has a 3/4 vote requirement, an 80% vote requirement, or a unanimous vote requirement, there's not many things that have a unanimous vote. But if there's any of those things on your AGM notice, you need to have the exact wording of the motion. So it's best to have the exact wording of all your motions and not let them be worded from the floor, but definitely the 3/4 vote motions is the most common. Those need to have the wording on your package. And if your meeting is an AGM, the notice must include the budget and financial statements as well. And I'm not going to go into a lot of detail about budget and financials because that can take hours. That's a whole separate workshop or 2. So as for what's actually on the agenda, the order of business is outlined in Standard Bylaw 28 or your own Strata's equivalent bylaw. So you could have amended Standard Bylaw 28. A lot of Stratas have not, but do check yours and make sure that you're following the agenda order of business that's outlined in your bylaws. So I'm going to just quote you what's in Standard Bylaw 28. Yours might be numbered differently, but I'd be very surprised if your wording is much different. So these are the things that need to be on your agenda. So certifying proxies and issuing voting cards, determining that there's a quorum, electing a person to chair the meeting if necessary, present proof of notice of the meeting, approving the agenda, approving the minutes from the last AGM or SGM, unfinished business, reports of council activities, if it's an annual general meeting, ratify any new rules, report on insurance coverage, approve the budget, deal with new business, including any matters about which notice has been given under section 45, elect a council if it's an AGM, and terminate the meeting. Sounds easy, right? Do you need to know everything that's there? No, you don't. You don't need to memorize it. Most of your AGM details are easily found in the Strata Property Act and in your bylaws. So know that they're there, know how to find them when you need them, look them up, and refer to them when planning and holding your AGM. So now we're going to get into a little bit more detail. But first, is an AGM even necessary? So in a very small strata, perhaps it's not. So you do not need to hold an AGM if all eligible voters waive in writing the holding of the meeting and consent in writing to approving the budget, electing a council, and dealing with any other new business. So that's something to think about if you're in a very small strata, especially currently now with the COVID-19 situation. Maybe you don't need to actually meet. Maybe everybody can agree in writing. So just something to think about, but it does need to be all eligible voters. So, and if two people share one vote, they must each consent. So that's the definition of a unanimous vote, is all eligible voters. So in almost all cases though, an AGM is necessary. So how to prepare the date, or sorry, excuse me, how to prepare for your AGM. You need to choose a date, of course, and work backwards from there. The date must be within 2 months of your fiscal year end, but that can be within 2 months before your fiscal year end or 2 months after your fiscal year end. It's not very common to have the AGM before your fiscal year end, but it is possible. So you do have that 4-month window. And of course, currently we have that extra little window because of the COVID-19, but that will end after the state of emergency ends. So to prepare for your AGM, start with your bylaw for the order of business. That generally forms the agenda. But how soon should you start to prepare? Well, I say a good practice is to start to prepare for your AGM as soon as you're elected. That gives you quite some time. As soon as you're elected, somebody should start a folder or a list of things that you want to be on your AGM agenda, and have that as a running list that you refer to every meeting. Whenever you're in a meeting, a council meeting, and somebody says, we should deal with that at the AGM, or we should make sure we budget for that next year, add it to your list. And that way you've got your preparations already organized ahead of time. And of course, the other thing that needs to be in your AGM, in your preparations, is beginning your budget planning. So start your budget planning about month 10 of your fiscal year, because you've got a fairly good idea of what your figures are going to be. Many stratas in BC have our fiscal year end at the end of December. So right now we've just got our final figures for our month 10, and we've got November and December to get final figures done. And so you can begin your budget planning. If you have any capital projects you want to do, now's the time to make sure you've got those quotes pinned down. You don't have to sign a contract, of course. You can't until the owners have approved the money, but you can get your quotes, 2 or 3 quotes. 1 or 2 is okay to just get a ballpark figure for planning, but the more quotes, the better. And you can plan your capital projects for the year. And then, of course, you need to write motions. We'll talk a bit more about how to write motions. The other thing to prepare for your AGM is solicit input from owners. So as I said earlier, the Strata Council sets the agenda, but an owner might have a topic that the council hadn't thought of that should be discussed at your AGM, or a project, or a bylaw amendment. There could be something that an owner has a fabulous idea. Just because they're not on council, that doesn't mean you disregard their idea. So do solicit the input from the owners. A good idea is to do that, maybe 3 months before the end of the year. Say, we're starting now to prepare for our AGM. Do you have any matters you'd like to see discussed at the AGM? Let council know and we'll talk about it. And also identify potential council members. Think about that ahead of time. Don't think about it the day of your SGM or your AGM. Now, perhaps you need to hold an information meeting. There's no prescribed notice period for an information meeting, but you need to make sure that you include all owners. You can't just send out the invitation to the owners that you like or the owners that you think are going to agree with you. You have to send out an invitation to an information meeting to all owners. There's no specific notice period. As I said, you can put up a sign and send out an email and say, hey, we're having an information meeting on Monday, the 23rd. You know, come there and hear all about some topics we're going to be discussing at our AGM. So you want to get information out to the owners, get a lot of the questions answered before the AGM. You can't take any binding votes, of course, at an information meeting, but you can look around the room at the nodding of heads and say, it looks like everybody understands what we're talking about. It looks like everybody agrees with this, but maybe around the room you find out that everybody really disagrees with this decision. They disagree with your planned action, so you may decide to amend what you're planning to do. And also at an information meeting, you can invite guest speakers. They might be helpful. You can invite your strata lawyer, maybe your depreciation report provider, maybe a contractor, maybe a VISOA representative, you never know. And they can help you to answer questions before your AGM, because at the AGM, you want it to stick to business. You don't want to get sidetracked a lot. So an information meeting is a good way to get the questions answered ahead of time. Of course, your resolutions, your motions need to be written correctly. Do you need the strata's lawyer to write them? It doesn't hurt, but of course that all costs money. So stratas are going to be tempted to not have the strata's lawyer write the resolutions for them. Can you copy wording from a previous year or from another strata? Well, you could, but if you're copying something that was done incorrectly, then you're just moving the problem forward. Can your management company write the resolutions? Quite often they do. Quite often the management companies will have a staff lawyer or a lawyer that they deal with regularly to help them write the resolutions. But when do you need the strata's lawyer to write them? I would say whenever you're spending the owner's money. So if you're spending the owner's money, I would have your strata lawyer write that resolution. And of course, the other occasion is if you're doing bylaw amendments. So if you're planning a special levy, you want to take money directly out of the owner's pockets. This is always going to be a 3/4 vote. And up on the screen, we're showing you all the things that must be in that wording. The purpose of the levy, the total amount, the method used to determine each strata lot share, the amount of each strata lot share, and the date by which it is to be paid. Now, quite often you're going to use your unit entitlement to determine each strata lot share of the levy. There could be the odd occasion when you do it a different way. So again, this is a resolution for your lawyer to help you with. You also could, for a special levy, you could charge a rate of interest, not to exceed the rate set out in the regulations, for any owner who might be late paying their strata lot, or excuse me, any owner late in paying their special levy. So you can establish that, that interest rate in your bylaw if you already have it, or right within the resolution itself. And again, that's another good reason to have your strata lawyer help you with writing the resolution. And of course, for bylaw amendments, it's always a good idea to have your strata lawyer look at your bylaw amendment resolutions, but those must be approved at an AGM or an SGM with a 3/4 vote. Bylaws are always a 3/4 vote. So if you have non-residential strata lots, or if you're entirely non-residential, this might apply to you. But if you don't have a mixed use strata, if you're all residential, this is not applicable. But it's something to think about. If you have some non-residential strata lots, you need to have 2 separate votes on bylaw amendments. You also need to make sure that after you've amended those bylaws, you file them at land titles as soon as feasible. So now you've got your notice package ready. how much notice do you have to give? So I'll tell you what the Act says, and then we'll talk about why that's a little different. So the Act says you must give at least 2 weeks written notice of an annual or special general meeting. But what you also have to pay attention to is the Interpretation Act. So the Interpretation Act is a very long, to me, very confusing act. I haven't studied it like I've studied the Strata Property Act, but the Interpretation Act talks about different ways of giving notice and different meeting dates. So first you need to know, are you giving actual notice or deemed notice? So actual notice is if you're actually handing it to the person. Deemed notice is providing notice by basically any other method. So if the person who has given you an address that is outside the strata, you can deliver the notice by delivering it in person, putting it right in their hand, or mailing it to the address they've provided. If they've not provided you with an address that's outside the Strata Corporation, you've got many different choices of ways to deliver it to them. You can personally leave it with them, leave it under their door, leave it with any adult occupant of their strata lot. You can mail it to them, put it into their mail slot if you have one. You can fax it if they've provided one, and you can email it to them if they have provided you their email address for the purpose of receiving that notice. Now, just because an owner is on your strata's email list for council meeting minutes and notices of maintenance, they have to specifically sign to have official notices sent by email. So check that and see what records you have for the person. So in most cases, you're not going to personally leave it with the person unless it's a very small strata and you can find everyone. So you're going to probably slide it under their door or mail it to them in most cases, or you might email it to them. So if notice has been given by any of those methods, except by putting it in their hand, the notice is deemed to be received 4 days after it was given. So this goes back to the Interpretation Act. So 14 days notice is required. The Interpretation Act says you don't count the day of delivery, add a day. You don't count the day of the meeting, you add a day. And you allow 4 days for deemed delivery. So 14 days notice, plus a day is 15, plus a day is 16. 4 days for deemed delivery is 20 days. So did anybody get it right when we asked another amount? 20 days is the notice period. And I've copied this from the Strata Housing website. It's sort of a different way of wording it. So when delivery is initiated, you count that as day 1. And you're probably not going to put notice in their hand. You could in a very small strata, as we said. So it's going to be deemed notice. So notice is deemed to be received after 4 days. The 2-week period starts on day 6. The notice period stops running 2 weeks later. So the AGM can be held on day 20 or later. And for myself, I always use 21 days. I use 3 weeks. It's just easier to count. If you want your AGM to be held on a Tuesday, you just count back 3 Tuesdays, and that's the date that you should send your notice out by. So technically 20 days, but 21 days is safe and easy to calculate. So, but what happens if after all that, you get it wrong? You don't give somebody exactly 20 days notice. So if you have deliberately given somebody less notice than required, it's possible that a court or the CRT could overturn your AGM results. So please do not deliberately withhold proper notice from any owners. But if you accidentally withhold notice, maybe you mistype their email address, or maybe you don't put sufficient postage on the letter you mail out to them. If it's an error, it's possible that it would be overturned by a court or the CRT. It's unlikely, but I'm not a lawyer and I'm certainly not a judge or a tribunal member. So it's unlikely that an error would go against you, but it is possible. So it's just very important to get that notice period correct. These are some other resources. There's lots of resources and links up on the VIZOA website. And here's the shortened link I was telling you about for the Strata Housing website. So it's just gov.bc.ca/strata. And that'll take you to all the information you need about the COVID-19 updates. And it has the plain language information about the Strata Property Act.